I just want to say thank you for inviting me here today. This is, as you may have just gathered from what I've said, still a work in progress. I don't have all the answers yet, but I'm working hopefully towards them. And I am exploring the links between the use of disqualification as a regulatory mechanism and its use as a mechanism for promoting accountability. And so these are the research questions that I've been working on. To what extent can the disqualification regime promote accountability? I'll be explaining in a moment why I've asked that question. I'm going to be asking whether disqualification to promote accountability is consistent with using it as a regulatory mechanism. Did the focus on accountability result in recent reforms to the disqualification regime? Did that focus on accountability mean that the reforms failed to address some substantial problems and long-standing problems with the disqualification regime? And then ultimately I'm working towards considering whether there is a need for a more radical reframing of disqualification that can promote both accountability and its, apologies for the misspelling, regulatory function. And just to step back, I'm talking about disqualification of company directors under the Company Directors Disqualification Act 2006, as amended by the Small Business Enterprise and Employment Act 2015. Now, as possibly most of us know, under the Company Directors Disqualification Act 1986, directors are most commonly disqualified under Section 6 of that Act, where they're directors of insolvent companies and they've been shown to be unfit to be concerned in the management of a company. The objective of disqualification under the CDDA has been set out in this very well-known dicta by the Master of the Rolls, Lord Wolfe, and Reuben Blacksburg Group plc. It's the protection of the public from those who are unfit to be concerned in the management of a company by means of prohibitory remedial action, by anticipated deterrent effect on further misconduct, and by encouragement of higher standards of honesty and diligence in corporate management. And I'm sure that's familiar to at least some of you. So just stopping there, what I'd say about this is that these set out regulatory goals. What do I mean by regulatory goals? That disqualification is intended to work by influencing behaviour through deterrence and standard setting. And disqualification is also a regulatory mechanism, can also be classified as a regulatory mechanism purely because it is a public enforcement mechanism. It is enforced through the medium of the Insolvency Service. So a key requirement of a regulatory mechanism is that it functions effectively and efficiently in influencing behaviour to achieve particular public interest outcomes. So that's why I'm talking about disqualification as a regulatory mechanism. Why am I talking about disqualification and accountability? The reason I'm talking about that is because of the emphasis on accountability in the proposals leading to the recent reforms of the disqualification regime. In the Transparency and Trust paper, in the impact assessment on the reforms and so forth, the government focused on disqualification and compensation orders as key measures to promote director accountability. Compensation awards are designed to promote directors' financial accountability to creditors. So these reforms and various other reforms were put in place. Compensation awards is a key a change to the regime. But the purpose behind these reforms was, as I say, to promote accountability, directors' accountability. Now, the emphasis on disqualification as a means of promoting accountability to directors is comparatively new. But it forms a part in the context of disqualification, but it does form part of a broader cultural phenomenon that is concerned with accountability. Melvin Dubnik, who has published quite a bit on accountability, tracked the use of the term accountability he did a survey of 1 million texts published in English in the US and the UK between 1800 and 2010. He found that the use of the term accountability increased sharply in the 1960s and 70s, but the steepest increase was in the 1990s and 2000s. And the concept of accountability has received increased attention in the corporate law sphere. We have my colleague, Professor Andrew Key's book, Board Accountability and Corporate Governance, published in 2015. And of course, we have your Mark Moore's book, Corporate Governance in the Shadow of the State, which also looks at the role of accountability in the corporate governance context. Now, in the present context, the focus on accountability can be traced directly to concerns about lack of bank directors' accountability in the wake of the financial crisis. So at the launch of the discussion paper on transparency and trust, which set out the proposed reforms to the disqualification regime, the then Business Secretary, Vince Cable, referred to people apparently responsible for major corporate failures seemingly going unpunished, particularly at banks, and he went on to state that this lack of accountability had caused the public to question the adequacy of the disqualification regime. So, what do we mean when we talk about accountability? Accountability is a notoriously difficult concept to define. There's a voluminous literature examining the concept of accountability. But when people talk about accountability, they're quite often talking about accountability as a process. And what do we mean by this? Accountability as a process has several core elements. First, a person or entity is called to account. They're obliged to recount or report their conduct to a third party, the audience. The actor, the person who's being held to account, must explain and justify their conduct against a set of externally set standards. The audience then evaluates the explanation, the actor's conduct, and passes judgment, and there must be the possibility of consequences being visited upon the actor, which may or may not be sanctions, could be rewards, depending on the conduct. So disqualification certainly looks as if it could function as an accountability process. When one thinks about accountability processes, when one talks about them, the literature tends to ask a number of questions. Who is accountable under the process? To whom are they accountable? For what are they accountable? What consequences follow as a result of being held accountable? And a less considered but very interesting question is, why are you being held accountable? What purposes does it serve? So, in the context of disqualification, we know that the people who are being held accountable as a result of previous research is the directors of insolvent owner-managed companies. It's rare for directors of dispersed share ownership companies to be held accountable under the regime. For what are they held accountable? For abuses of limited liability, misconduct, gross incompetence, but not for commercial misjudgment. And to whom are they held accountable? Well, in the first instance, to the Insolvency Service, to the regulator, or the courts in actions brought by the Insolvency Service. But the question there is, who is the Insolvency Service representing? It's obviously a placeholder for other interests. The reforms to the disqualification regime make clear that what we're concerned, one group that we're concerned with is, of course, creditors. That disqualification holds directors accountable to creditors. That's the rationale for the compensation awards. But as we've seen in on the earlier slide with Lord Wolf's dicta, the disqualification regime also protects the public. So the Insolvency Service is standing in for a wider range of interests. To the question, what consequences follow? Well, on one view, this is quite straightforward. What consequences follow from the disqualification regime is that you get disqualified from, and you can't act as a director or be involved in promotion, management of companies, so forth. Section 1 of the Disqualification Act. Also now, the new Section 15A of the CDDA provides that directors can be disqualified directors of insolvent companies can be required to pay compensation to creditors or to contribute to the assets of the insolvent companies. But Mulligan has argued, who's written quite a bit on accountability, Mulligan has argued that the consequences that are required by an adequate accountability mechanism must have a particular character. And he argues that accountability is incomplete without effective rectification. Accountability involves an element of retributive justice in making the guilty pay for their wrongdoing. And just to pause at that point, rectification and retribution are not the same thing. Retribution is narrower than rectification. Retribution focuses on the person who has caused harm and is concerned with bringing home to them the consequences of their actions by, as Mulligan says, making them pay for it in some way. Now, that idea of pay for it is used somewhat loosely. It doesn't require financial penalty, and it certainly doesn't require any payment to the person who has been harmed by the conduct. Rectification, on the other hand, looks both ways. It focuses on both the victim and the offender. And the key aspect of rectification is that it requires that things be put right for the victim through the payment of compensation or damages. Now, hitherto, the disqualification regime has not been rectificatory. The compensation awards may alter that. But disqualification itself may be considered retributive, at least in the sense of being seen to make directors pay for their wrongdoing. And so the disqualification process may be counted or may have the potential to be an adequate accountability mechanism. One of the interesting questions, though, is what are the rationales for promoting accountability? What could the rationales be? Well, in one view, accountability is simply a procedural thing. It's not a substantive value in itself. It's an instrumental process that's used in pursuit of different ends, depending on the context. And certainly this is one way of viewing the disqualification process. Disqualification, insofar as it is an accountability process, is used to promote the protection of the public through deterrence, through standard setting, and also the thrust of the recent reforms is that it's necessary in order to increase market trust. That was very much what the government said it was getting at with reform of the disqualification regime. But this, however, I think downplays the significance of accountability as a concept. There's never been previously talk about accountability when talking about what the goals of disqualification are. And there was no need to talk about it now. It's possible that the focus on accountability suggests that there's something important in the concept of itself, that accountability has a value of itself. So what would that be? Why would that be? Well, Mulligan has argued that accountability is a relational concept. It focuses on whether an actor is sufficiently accountable to an audience for what they've done. There must be some nexus between the actor and the audience such that there is a moral need for the actor to render an account to the audience. And as Mulligan says, accountability is required because the rights and interests of the audience provide the rationale for accountability. So the question is, what relationships give rise to the need for accountability? And he identifies two. First of all, the principal-agent relationship. And the thing to note about this relationship is it exists before a priori to the conduct that the agent must explain. So it's a relationship that's in existence before the conduct that the relationship must explain and justify. He identifies the second rationale, which is the vindication of interest rationale. And the point about this is that this relationship, the relationship that arises on the vindication of interest rationale, arises after and as a result of the conduct that gives rise to the need to provide an account. So just to explain that a bit more, turning to the principal-agent relationship. This is, in fact, the most commonly rehearsed rationale for the need for accountability in the accountability literature. The idea here is that accountability is needed to address agency problems. So where a principal entrusts another person with authority to act as his or her agent, we know that there's a risk that agents will shirk or act in their own interests. And so the argument is that when principals delegate authority to agents, agents are liable to account to their principals for the manner in which that authority is exercised. Now, arguably, this does provide an explanation for the need for directors to be accountable as creditors in the context of disqualification. Mokel and others have argued that when creditors lend money to companies, this gives rise to a number of agency problems between creditors and managers, particularly owner-managers. So, for example, asset substitution, so after the debt has been granted, managers have an incentive to increase the riskiness of the company's business, to exploit opportunities that can increase the returns to shareholders, but that will go very badly wrong, have a lower chance of being successful. Any increased returns will benefit the shareholders, any loss will be shared between the creditors and the shareholders. So accountability could be necessary for two reasons. It could be necessary to reduce agency problems by deterring conduct that reduces creditor wealth, or something that's not on the slide. It might be necessary as a matter of commercial fairness. It might be necessary for creditors to be able to hold directors to account because they've acted in a way that breaches creditors' legitimate expectations about how the company would be run after they've lent the money to it. And because, in effect, creditors have been exploited by directors after the event. So if that provides an adequate rationale for directors' accountability to creditors, the question is whether disqualification acts as a sufficient accountability mechanism. Well, the first thing to note is that disqualification per se is not rectificatory, obviously. And it was not perceived as being enough to promote accountability to creditors. The Transparency and Trust paper noted this, said the creditors were dissatisfied, and that was the reason for the introduction of compensation awards. It seems that rectification was considered to be necessary to promote adequate accountability to creditors. This produces a broader question of whether, in order to promote adequate accountability on a principal agent basis, rectification is required, where the principal's interests have been harmed. There may be a broader question there. Turning to the vindication of interest rationale, Mulligan argues that this is required where the actor's conduct harms the rights or interests of others, and it's required because it gives those others a voice and demonstrates that their interests count. It demonstrates respect for them as persons. And this rationale could support accountability to the broader community, but it only comes into play because the rights and interests have been harmed. So rectification in this concept, because of the range of people that directors could be accountable to on this basis, rectification in this context is not feasible. It could lead to on-cap liability, it could lead to over-deterrence of directors. It would be contrary to the general position taken by the courts on on-cap liability. So disqualification could serve to promote, disqualification per se could be sufficient to satisfy the demands of this particular form of accountability. It's retributive, but arguably retributive insofar as it makes directors, as I say, pay for what they do. But the question is, does it make directors pay for what they do? And there are some questions over this, given the target of the disqualification regime, the target being owner-managers. And there are long-standing criticisms of the use of disqualification against owner-managers. Hicks' research shows that owner-managers do not feel that they suffer a stigma from disqualification, that the stigma and upset that they feel primarily comes from the fact that their company has become insolvent in the first place. Disqualification does not add much to that. Again, as far as owner-managers are concerned, it's not clear that they suffer any reputational effects, and they can continue to trade as sole traders. And there has been some querying over the length of disqualification periods and whether they are sufficiently lengthy on average to either act as a deterrent or, in this context, to vindicate the interests of those harmed by directors' conduct. Could the retributive aspect of disqualification be strengthened by fines instead of compensation awards? That's a possibility. Of course, you then have the problem, a separate problem, which Williams has addressed, of whether there's sufficient solvency in the disqualified director population such that they would be able to pay any fines. The second question I've been addressing is accountability consistent with the use of regulation? Is it consistent with the use of disqualification as a regulatory mechanism? If we're thinking that accountability, the disqualification process as an accountability process is simply instrumental in achieving other ends, such as protection of the public, such as promoting market trust, then it is perfectly compatible. Accountability is perfectly compatible with the use of disqualification as a regulatory mechanism. But if we're thinking of accountability as a good in itself, for example, on the basis of the vindication of interest rationale, then it's possible that promoting accountability through disqualification is not consistent with its regulatory aspect, its use as a regulatory mechanism. Why? Because accountability focuses on whether an actor is sufficiently accountable to the audience for what they've done. It's backward-looking. Whereas regulation is forward-looking, action is justified where it has potential to influence future conduct. Now, if you're focusing on accountability, remedial action, enforcement action could be required, even if it wouldn't affect the future behaviour of others. For example, even if there was no deterrent effect or standard-setting effect. The idea that accountability is good itself could lead to the idea that more and more enforcement is just good. And actually, there was evidence of this attitude in the discussion in and around the reforms to the disqualification regime. So the government said in its response paper, there's always a sense that more could be done to ensure accountability for directors' misconduct, particularly in key sectors that are following major corporate failures, and a dissatisfaction with there being insufficient enforcement. 36% of all insolvency practitioners in a survey carried out for the Insolvency Service in 2012 wanted enforcement to take place in as many cases as possible. And so this focus on accountability could lead to the view that problems with regulatory mechanisms such as disqualification could be improved or could be addressed by increasing levels of enforcement and funding. This seems unrealistic. The Business Innovation and Skills Committee made the unworldly suggestion that additional funding should be made available to the Insolvency Service so that they could disqualify and sanction all directors who were guilty of misconduct. Focusing on accountability may also have deflected attention from problems with the disqualification regime, long-standing problems with the disqualification regime operating as a protective and regulatory mechanism. And there's been a huge amount of research done on this, not least by Richard sitting here. Long-standing doubts about sufficiency that were reinforced by the survey that I've referred to, commissioned by the Insolvency Service in 2012. Survey of 100 directors found that only 4% of them were aware of the Insolvency Service's enforcement and communication decisions. 43% were aware of disqualification itself, and of that 43%, only 37% thought it was adequate, was effective in deterring wrongdoing. So insofar as disqualification is meant to regulate conduct by deterring and by raising standards, it's not going to be doing a very good job if the directors aren't actually aware of it. But the reforms did not focus on this and did not discuss it. The papers did not. The discussion papers didn't canvass this problem. So focusing on accountability may have led to the wrong kind of reform. So, for example, the focus on promoting accountability to creditors led to the introduction of compensation awards. But as Williams has suggested in his 2015 paper in the JCLS, as R3, the Insolvency Association, has suggested, compensation awards may not in fact be effective. There may not be an increase in the amount of awards, amount of money recovered from directors, the amount that's already retrieved under civil causes of action under the Insolvency Act 1986. And indeed, the introduction of compensation awards, R3 suggests, may lead directors to fight actions brought against them rather than just simply giving undertakings. And therefore may use up Insolvency Service resources and lead to actually fewer disqualification orders and undertakings. And if so, this can undermine the regulatory effect of disqualification, can also mean that it doesn't lead to actually greater financial accountability at all. The Chancery Bar Association raised another issue, which is that they argue that compensation awards were inappropriate because they constituted the inappropriate use of public power for private ends. And this raises a broader question of when should accountability be promoted through public enforcement. And Stewart and Sunstone, in their Harvard Law Review article, argue that public enforcement is desirable when the harm caused by conduct is diffuse or affects a large number of individuals, where the costs of private action outweigh the benefits to the individual. A number of you will be very familiar with these arguments, where a public authority is in a better position to identify a wrongdoer and gather evidence on individuals affected, and the aim is to achieve a collective good. Now, I'd suggest that this clearly supports using the public mechanism of disqualification and a fine to promote accountability on the vindication of interest rationale. Query whether it supports the use of disqualification to promote accountability to creditors. I'll be interested in your thoughts on this. The question there is compensation to creditors achieving a collective good, or is it just, as the Chancery Bar Association suggested, serving private interests? And it is a contentious issue as to whether the relationship between creditors and companies and owner-managers is a private or public concern. Is it a private matter or is it a public matter? and should we be leaving creditors to protect themselves through their contracts? I don't as yet have an answer to that. I'd be interested to know what you think. If we are going to use disqualification, just to step back, disqualification has been heavily criticised. It's not clear that it's achieving the goals that have been set out for it, as articulated by the Core Committee, as articulated in the Blackspur case. If we are going to use disqualification as a mechanism to promote accountability in this, and if we are going to, on the, say, the basis of vindication of interest rationale, for example, and if we want to improve its use as a regulatory mechanism, then I think we do need a fundamental rethink of the disqualification regime. The answer is not going to be, contrary to the views expressed during the reform process, the answer is not going to be more and more enforcement. That's not going to work from a regulatory perspective for the reasons identified by Parker. Relying on heavier and heavier deterrence is a game that can never be won, because whatever the penalty is set will always be too small to deter those whose wrongdoing is so profitable it doesn't matter, or those so disorganised they do not notice possible sanctions before it is too late, and that's probably a lot of owner managers. Also from the perspective of accountability, as the current disqualification regime operates at the moment, where it targets owner managers, I've already suggested that it's query whether it really does make them pay for what they do, for the reasons I've outlined previously. So we need to improve disqualification as a regulatory and accountability mechanism, and so how do we do it? Well, one possibility, and a controversial suggestion, although others have made it, and it occurs in Australia, is that we disqualify directors of dispersed share ownership companies. We focus more on their conduct rather than the conduct of owner managers. This has regulatory and accountability advantages. From a regulatory perspective, this would be a very high-profile thing to do. It would send it would send out messages. Because it received more attention, it would have a greater deterrent effect. These are the potentials that would need to be explored. From a accountability perspective, if we are concerned with the vindication of interest rationale, if we say directors should be held to account because they can harm the interests of a broad range of people, it's the activities of directors in dispersed share ownership companies that have the greatest potential for impacting on the broadest range of people and impacting on them most seriously. So I do think that this needs some further consideration. In conclusion, the present regime neither adequately promotes regulatory goals or accountability goals. And the focus on accountability, I'd suggest, has deflected attention from the need for a far more fundamental review of the disqualification mechanism.